Okay, all persons having demanded a form of business before the Honorable United States Court of Appeals for the Fourth Circuit, I must draw now and give their attention, for the court is now sitting. God save the United States and this honorable court.
Brignac. Proceed.
Thank you, Chief Judge Gregory. May it please the court, Eric Brignac for Chris Tucker. The district court erroneously concluded that clear and convincing evidence supported involuntarily medicating Mr. Tucker. First, clearly erred in concluding that the forced medication would be substantially likely to restore Mr. Tucker to competency. Second, it legally erred when it weighed the government's interest at stake. And additionally, the court erred in simply extending Mr. Tucker's confinement for the involuntary medication, which was outside of the scope of that which was authorized by Section 4241D. We'll start with the substantial likelihood prong. The district court relied heavily on two things in order to conclude that the medication, the forced medication, would be substantially likely to render Mr. Tucker competent. It relied heavily on Dr. Grady's testimony, and it relied heavily on the report by Dr. Stribling-Riley that said that Mr. Tucker had been restored to competency. Both these are clearly erroneous because they both go back to that erroneous report by Dr. Stribling-Riley. If the court looks, Joint Appendix 1282, that report that we're talking about.
Mr. Brignac, where is all this headed? What do you want to happen at the end of the line? If you say, well, you can't voluntarily medicate, what would you have the government do? Do you want the government to just release Mr. Tucker outright, or do you want him to go to trial, which he's not really competent to render assistance to his counsel, or maybe to understand what's going on? So what's the end point here? Where does all this end? What is it exactly that you want the government to do?
I think there are two things that the government could do if this court rules in our favor, and there's one that I certainly would prefer. The court should order Mr. Tucker released, physically released, not dismiss the indictment, although I do think as a practical matter, because he can't be made competent, that would be the practical end game. But I think there's no statutory authority to detain him. Now, at the end of Section 4241D, it does indicate that once this is over and if there is no substantial likelihood of restoration, the defendant is subject to 4246 or 4248 proceedings. And we've already gotten a preview.
Well, but if the government is simply releasing him, doesn't the government have an interest in protecting child victims? And wouldn't an outright release place that interest in jeopardy?
Your Honor, the idea that the government can detain someone if it believes he's a danger, that's well outside of due process. There are statutory mechanisms for that. There's 4246 and there's 4248. Mr. Tucker would have to go through all of those proceedings. Now, we've gotten a preview of coming attractions. The doctors at Butner have indicated that they do not think that Mr. Tucker is actually dangerous. So he would not be committable under 4246 or 4248. But certainly Congress did not intend for 4241 to be extended indefinitely. It created a mechanism for that to address exactly Your Honor's concerns. Now, Mr. Tucker, when Dr. Stribling-Riley wrote her report, he had been on dissolvable olazapine for 5 months. That's at Joint Appendix 1282. He'd been on from October 2019 at least to February 2022. And that was at 25 or 30 milligrams. And they did do a blood draw, and they said that there were therapeutic levels of the medicine in his blood. So that's the remedy that the government says will restore him to competency. Now, in that very report, with 5 months of the medicine in his blood at therapeutic levels, he was still talking about the fact that the prison law library had been hacked. That is not someone, Your Honor, who can substantially, I'm sorry, using the wrong word. That is not someone who can assist his attorneys. That is someone who is still suffering from those delusions. And I think that gets to the key of what's going on here. because there are two ways in our law under Dusky and under 4241D that an individual can be incompetent. They can simply have no idea of what's going on, or they can be unable to assist their attorneys. And we're all on prong 2 here because of his delusions. At no point have those delusions gone away. And the only reason that Dr. Stribling Riley concluded that he was competent to assist his attorneys was because she did a report where she didn't talk to his attorneys, she didn't review any jail calls, she didn't talk to anyone in his family. She didn't do any of that. She didn't do any of the things to get to the delusions. And in fact, in the one conversation she seemed to have with him, he's talking about the fact that the law library's hacked. I don't want to rely too much on my own experience as a defense attorney, but you client cannot assist you if you're putting things in front of him and he's saying those aren't the right words, somebody must have hacked something. And even the
Can I
prior.
ask you, I think this case is really hard in a lot of ways, and I'll just give you one factual question that I'm trying to get my hands around. So one of the issues is whether or not your client ever fully complied with the medication regimen for a period of time. And they say he didn't, and you say he did. But I just have a very straightforward factual question. What 3 to 4 month period, like what months in time is it your claim that your client was fully complying with the medication regimen?
There's one, Your Honor, where he was fully compliant and one, Your Honor, where he was almost fully compliant. Number one, and I don't think, and I very much apologize for this, I don't think this was put in our briefs or clear in our briefs, so it is very much in the record. October 2019 to February 2020, because he was on the dissolvable olanzapine. And all the evidence in the record says that you can't cheek that, you can't hide it, put it on your tongue, it dissolves. And if you look in Joint Appendix 893, that's Dr. Grady saying he was on the dissolvable medication. Joint Appendix 657, Dr. Koenig's testimony in September 2020 was saying he was compliant. So that was dissolvable, and that was 5 months, October through February 22, with 25 to 30 milligrams. So again, the higher dose that they said. Your Honor, I would also say, and again, not 100% compliance, but 100 to the 90s. And let me see, you're right, this is a complicated case. I have a lot of notes. November, December 2018 through January 2019, he's at 100%, 97%, 84%. But I also want to get to Your Honor's a deeper question there, which is part of the reason the government's saying, oh, he wasn't compliant. He was so close. If only he'd fully taken the medicine, is it's taking this evidence from the blood draws. And Joint Appendix 342, Dr. Grady admits, we weren't actually as diligent as we should have been about the blood draws. He says, I take responsibility for that. Mr. Tucker looked like he was close. I wasn't doing my job properly. Joint Appendix 341, and again, I don't think this ended up in the briefs and I'm kicking myself, but Joint Appendix 341, Dr. Grady's testimony, they're saying they gave him the wrong pills for a little while. He was supposed to be getting the olanzapine, they messed up his pills. So if you then you give someone the wrong medicine, you do a blood draw and say he's not compliant. And by your own admission, you're not doing the blood draws properly. And as the government, you have the burden of proof by clear and convincing evidence. And you're trying to say, well, we don't think Mr. Tucker was compliant. I think it's clearly erroneous to say the government has met that burden of proof.
Well, I was just trying to figure out, how does that cut though? Because as I understand your argument on the cell prong, not on the delay prong, but on the cell issue, is there's the line that you quote in your brief, and it's a good line. Like you can't keep trying over and over and over again and failing and then insisting that at some point it's going to work. Now, their response to that is, we've never actually tried the thing the district court ordered here, because the thing the district court ordered here has never actually been tried before. Because I do take your point. If at some point you try and it never works, then it's not going to work. But so I guess if you're telling me that there were things that were done wrong with it previously, I'm not really sure how that cuts for the cell analysis, because on the one hand, it means the government had a chance, and at some point they can't keep trying again and again and again. But on the other hand, it undercuts your claim. One of the claims you make in your brief is, we know this isn't going to work because it hasn't worked in the past. And their response to that is, well, we haven't actually tried this in the past. So what do I do with that?
Exactly, Your Honor. So first, I think one thing Your Honor can do if you don't want to go into that mare's nest is look at the October 19th to February 2020, because that was 5 months dissolvable olanzapine. and he's still talking about the prison law library being hacked. So you can just, I think, start there and stop there. But I also think this gets to where I very much, and believe me, I've thought about Your Honor's point that, you know, hey, the medicine wasn't ever given to him properly. We're not sure, even if it was the government's fault, don't we still have a factual problem that he never got the medicine? And that's where I think you have to remember that this isn't I have an infection and I go into the doctor and he's trying different antibiotics and, oh, I'm voluntarily going to him and the like. This is a human being who is being detained without any criminal conviction whatsoever. And due process requires the government to have some basic standard of care, and they have the burden of proof. And if the government comes back and says, well, Your Honor, he wasn't fully compliant, you know, the numbers, I mean, we look at the district court's first order and you see these 4 to 4 month periods with almost 100% compliance. Government counters, says, no, Your Honor, you know, the blood draws.
Counsel, you're up against a specific finding that the district court made and that's subject to clearly erroneous review, that there was a past record of improvement when the appellant here was more compliant. And I don't know how he found Dr. Gavely or whatever to be a highly credible witness, and he made the correct finding under the correct standing. He says involuntary medication is, quote, substantially likely to restore competency, and under cell, that's exactly what he's supposed to do, to make exactly that inquiry. He made exactly that inquiry. He made several specific findings about the credibility of the witness and about the potential of the treatment when there was compliance. And I don't. That's just a hard thing to overcome.
It is, Your Honor, but we overcome it here. I think he's relied on improper evidence, which I'll explain in a second. And I think there is a firm and definite conviction that a mistake has been committed. He relied on Dr. Grady. Dr. Grady relied on the Dr. Stribling-Riley report, which the government admits was effectively withdrawn. And Dr. Grady himself says, you know, it was all old records, Joint Appendix 1392. We didn't talk to Mr. Tucker. Nothing but cold records, which all predate Dr. Koenig's testimony. It was stale, it was improper. I also, Your Honor, want to get to, again, this inability to assist counsel. This is the first prior to the first cell order. Joint Appendix 1139, Dr. Stribling-Riley's report, November 2018. She says the olanzapine and the fluoxetine helped, but not with his delusions. Quote, suspiciousness regarding others remained. He continued to believe the government planted evidence on him. There was a specific conspiracy against him involving the FBI. Joint Appendix 1168, her second report, May 2019. She says he can't, quote, cooperate rationally with counsel. And again, at least in terms of the first report, she's saying that he was compliant with the medication. And she's getting that from the Bureau of Prisons records. And the government wants to come in and say, well, actually, we don't think those records were good because he was cheeking and our blood draws show this, that, and the other. But the reason that counter doesn't work is because the government itself admits we weren't doing the blood draws properly. So to say we're not taking your blood properly, we're not doing this properly, but that should be enough to undercut the Bureau of Prisons records, it's not enough. And just as I'm here on clear error, the government in the district court was on clear and convincing evidence.
I have a couple of questions about the duration issue, not the cell issue. So I just have a factual question to start with. All of these arguments about how long he's been detained, it seems to me obviously were available during the previous appeal. Is that not right?
Yeah, I think, yes.
And none of them were made?
We did not, well, not in the appeal, Your Honor.
Right.
We did in the district court, you know, as soon as the government moved for that third period of restoration, if the statute says you get 4 months,
right,
then you get another period. then the government moved further.
Well, but what about the district court's conclusion that there was something, I mean, I will confess, I find this waiver issue really hard too. Because I agree, there was at one point an objection that you say he's been objecting for 3 years. And I think you have that date in 2019 or 2020 where he starts objecting. But then there's stuff after that that looks a lot like acquiescence, right? I'm thinking of September 23rd, 2020 and February 23rd, 2021. And I look at the transcripts and I do not see defense counsel saying he's being held illegally. And so I guess there seems like a lot of waiver issues here and I don't know what to do with those either. So would you like to address that?
Yes, I would. Thank you very much, Your Honor. So I agree with you. I think that there was points in after 2019. I think that written motion to release, that is, I mean, boy, I'm building my entire house on that because it was done and I don't think the district court ever properly addressed it. But even if, and I will say for the point of Your Honor's hypothetical, even if some of these later periods, there was some acquiescence, the government was in no way prejudiced by this. This isn't a case where we didn't object to a witness on the first day of trial, government puts on its whole case, and then a week later we say, hey, that guy shouldn't have testified. You know, then there's obvious prejudice, there's detrimental reliance, etc. What we wanted was for Mr. Tucker to be released, physically released. That's still what we want. And the government has been in no way prejudiced by this, no detrimental reliance. So even if there are some later waivers, you know who suffered for that? Chris Tucker. He probably should have been out 2 or 3 years ago. Should have been out in 2019. He wasn't, but the waiver in no way hurts the government, so that should not be the basis.
We don't know that the government has not been prejudiced by this, and I don't know what witnesses are necessary for the individual to be brought to trial, but maybe those witnesses are no longer available, or maybe their memory has faded. And as Judge Heitens points out, a lot of this period of detention was unobjected to by counsel. And finally, is the government really to be defaulted for wanting to bring someone into a position of competency and to make sure that when trial goes forward, the individual is cognizant of the proceedings? I mean, you don't want the government to shove somebody into a trial when they don't know what's going on and they can't assist their attorney.
May I answer, Judge Gregory?
You may.
Thank you. Just briefly to get to your first question, Judge Wilkinson, I do think if, say, this case does somehow ending up going to trial and Christopher Tucker does then try to move to dismiss or say somehow the delay prejudiced him and prejudiced his trial, then I think all the waiver issues come up and the government can say, oh, this prejudiced us at trial too. All we're asking for here is his physical release. This has nothing to do with the merits of his case. So I don't think the waiver affects. And just very briefly to answer your second question, certainly the government does have some interest in doing this, but that's why we have a whole cell hearing. That's why we have a whole cell framework. So certainly the government wants to bring him to trial, has an interest in bringing him to trial, but that's why we're here today. Thank you.
Thank you, Mr. Gregory. Ms. Niemeyer.
May it please the court, Julie Niemeyer for the United States. The facts supported involuntary medication in 2019, and they continue to support involuntary medication today. The vast majority of the delay in this case has been brought about by Mr. Tucker's choices. His choice not to comply with his medication regimen and his choice to assert his right to contest involuntary medication. This court should affirm the decision of the district court, permit the government the opportunity it has been seeking for years to effectively treat Mr. Tucker, restore his competency, and give him the trial that he wants.
Counsel, can I ask you, I mean, we are where we are and there's nothing we can do. And I will say this, that as a former government lawyer, you are not responsible for some of the things that I'm about to mention. It seems to me that at least in the early days, people were really loosey-goosey about these statutory, I mean, there's a question about whether he waived these objections, but I guess I'm troubled that it seems that for the first couple of years, we were really loosey-goosey about the statutory guidelines here. Would you agree with that?
Would not agree, Judge Heitens, and this is why. When Mr. Tucker was first admitted to Butner in June of 2018.
Oh, no, I'm talking before Butner. I'm talking about when he's going to Chicago and it takes forever for him to get there. There seemed to be some really loosey-goosey stuff in the early phases.
I apologize, Your Honor. During those periods, there were some transportation delays in getting him transported to his evaluations. There was first an evaluation in Chicago, and then following his return from that evaluation.
And those are delays that caused us to miss deadlines, it looked to me like.
I believe for the first evaluation, BOP received an extension on their reporting deadline from the district court. So I don't know if there's any problem there. But following the first evaluation, it was the defense team that raised concerns about Mr. Tucker's current condition following his return from Chicago. And that is what prompted the district court, out of an abundance of caution, to undertake a second period of evaluation. And that is when Mr. Tucker went to San Diego, was evaluated a second time, and that resulted in the finding of incompetence at that time, which was then issued in May of 2018. So the finding of incompetency was May of 2018, and that's the beginning of the clock, so to speak, when we look at the government's process of attempting to restore Mr. Tucker, which ultimately was successful in February of 2020.
Are you or the government, I guess, aware of any case where an individual is delayed this long before we decided whether we can even medicate them under cell? This feels like a really long time.
I'm not sure there has been a case in the Fourth Circuit that I'm aware of, Your Honor, but if it would be helpful, Your Honor, there is a case in the Second Circuit, the Megasuba case, which is very parallel to this one. And in that case, the defendant's delay from the finding of incompetency until the eventual cell order was issued by the district court was 19 months. And in this case, we actually have a time period of just less than 18 months from the finding of incompetency, which was May 2018, until the issuance of the cell order, which was in October of 2019.
And then I guess you'd say that everything that happened since then is a result of the defendant's appealing of that cell order?
Exactly, Your Honor. Once that first cell order was stayed by the district court, the government was powerless to take further action without Mr. Tucker's compliance. So facing that cell order on appeal, Mr. Tucker made the decision to begin voluntarily complying with his medication. And so to answer Your Honor's question from my colleague's presentation, there is very critical facts at JA 1394 and 1395. That's Dr. Grady's report, which details the entire history of his medication levels. And it documents the levels that he was at in the fall of 2019. They changed him to the 25 milligram dose in August of 2019. But then thereafter, Mr. Tucker refused several blood draws. And so again, Dr. Grady was operating without exact knowledge of what the medication was doing. And then finally in January, they increased the dosage to 30 milligrams.
So what do we do with Dr. Riley's testimony that he's had 100% compliance since May 2019? That's at JA 304, where Dr. Riley says that. I mean, again,
he had fairly good compliance.
No. There was testimony that said he had 100% compliance. Dr. Riley said that.
Well, Your Honor, even so, that compliance was at a lower dosage of medication, which ultimately did not prove therapeutic for Mr. Tucker because of the lack of blood draws. It was not known at that time that Mr. Tucker was a rapid metabolizer, which was a biological issue where he processed the medication more quickly than perhaps an average patient. And so when that information was obtained, that's when his treatment team went forward with a higher dosage to attempt to attain a therapeutic level in his blood. And that's what brought us to January of 2020, when his dosage was finally increased to 30. The evidence supported that decision. And then in February of 2020, following this period of voluntary compliance, he was restored. The problem is that his levels were not maintained after that date.
Counsel, you said he was restored. What do you mean by restored?
In the opinion of Dr. Stribling Riley, in February of 2020, he was no longer mentally incompetent. She had observed him.
In this case, mentally incompetent, we're talking about schizophrenia with ideation of delusion, right? So you're saying he's competent once he stops having delusions about conspiracies and the government, because they seem to be contextual to the idea that the government is doing something wrong. So you consider once you have suppressed the ideations of delusions, he's competent. That's right. Is that the end game for your therapeutic objective?
Well, Chief Judge Gregory, the standard for attaining competence is not that there is a complete absence of mental illness.
I didn't say the standard. I'm asking what is your objective?
Mr. Tucker has to exhibit a factual understanding of the charges and the ability to rationally assist his counsel in his defense.
Well, he understands what's going on that he's being charged of. Been there 5 years. I think he understands that. The question is, you equating with suppression, if you suppress delusions, then he can help his counsel. Is that right? Is that the theory?
I think that's part of it, Chief Judge Gregory. But
what's the other part?
The ability to rationally assist his counsel, and the difficulties that Mr. Tucker encountered were partly caused by his personality disorder. So we have not only psychosis here, but also personality disorder. And when Dr. Stribling Riley applied that very specific standard in February of 2020, she wasn't saying that he was no longer suffering from personality disorder. She was saying that to the extent that Mr. Tucker exhibits unusual behaviors in communication with his counsel and with others, it's caused by his personality disorder and not by psychosis. And it does not prevent him from rationally assisting in his defense. So with that finding, which was adopted only after she had been treating Mr. Tucker since June of 2018 and observing him for the immediately preceding 4 months during his third hospitalization period, the district court found that opinion credible.
So I get this correct. Once you get his blood levels to the therapeutic level, and therapeutic in basics means that based on what the scientists say that at this level, it should work. We don't know it's going to be effective, but the metric is just a therapeutic level, not really results. Once you get it there, then after that, if he tells you, I have not experienced delusions, then he's well enough to go to trial, right? Is that right?
Well, yes, Your Honor, if he retained that ability to rationally assist counsel, but that's
no. You're determining helping counsel with delusions as being the barrier. What else do you have? He says personality. A lot of people have personality disorder and they function very well in many high placed jobs, very important jobs. And so, but once he gets to that level, therapeutic level, and he reports no delusions, you equate that with he can help counsel. Is that right?
I can't speak to that, Your Honor.
Well, you have to speak to that because that's what we're doing. Well, that's the point. You hear, we're trained in the law and we're talking about science or to dictate it. That's why you can't keep people forever and ever and ever. For example, what do you want? If you get therapeutic levels and he says, I had one occasion of delusion, do you want 4 more months to get him to 0?
The key, Your Honor, is maintaining.
Would you answer my question? If you get him to 4 months of therapeutic levels and he says, I only have 1 instance of delusion, is that enough to say he can go to trial? Because until we get to that, we're just going back and forth with lawyers, counsel, your side, his side. I'm just asking, what is your metric? Is that enough? 1 instance of delusions after that. Is he healed? For purposes of competency?
Your Honor, I think if he had maintained a therapeutic level for 4 months, then yes, he would be restored as long as he maintained the therapeutic level of medication in his blood. I think the opinion of the experts is that that would restore him. And that's what the government is seeking, because we haven't had the opportunity to have a 4-month period of a therapeutic level to date. We simply weren't able to maintain that therapeutic level because of the very parameters of 4241, because he wasn't hospitalized beyond the end dates of what the statute permitted. So if he were maintained at a therapeutic level, it was the district court's conclusion based on the medical evidence and the recommendations that that would restore him. There was a substantial likelihood, as the statute, as cell requires, there was a substantial likelihood that he would be restored.
Right. I have a couple of questions about the government interest, and I guess I want to start with a factual question that I think I know the answer to, but I just want to confirm. Factually speaking, is it true that at the start of all of this, the government was willing to let him plead guilty and to recommend? I know it would not have been binding on the district court, but the government was going to recommend 5 years. Is that factually true?
No, Your Honor.
Okay.
What the government agreed to was a plea agreement to a single count of transportation of child pornography. This was not an 11C1C plea.
No, I know it wouldn't have been binding on the district court, but my sense was that that the government was going to recommend 5 years.
No, Your Honor.
That's factually false. Okay.
This was a plea to a single count that carried a statutory range of 5 to 20 years.
This was the case where we went all the way through the plea hearing, and at the end of the plea hearing, he said, "Turns out I don't want to plead guilty."
Exactly, Your Honor.
Had the government made a sentencing recommendation at that hearing?
No, Your Honor.
The government was going to recommend a downward departure, though?
That is not in the record, Your Honor.
Okay, fair enough. You've now pointed that out, but factually speaking, was the government going to recommend a downward departure?
I can't answer that, Your Honor. I'm sorry. I could supplement with a letter later.
Why can't you?
I don't know, Your Honor. I'm sorry.
Well, should you know you're here to represent?
To my
The
knowledge,
government?
there was not a recommendation. But if I find later that I'm wrong, I will advise the court.
So, I mean, so let's just, okay, so posit for the sake of argument that's true. We have to obviously get to the bottom that that's true. But positing for the sake of argument that that were true, why wouldn't that bear pretty heavily against the government interest in restoring this gentleman to competency, considering he's now been detained for longer than that?
Well, Your Honor, even if that were the case, the government has a significant interest in not only a period of incarceration, but a period of supervised release in this case. There's a significant interest here in obtaining appropriate supervision of Mr. Tucker following his conviction in any period of incarceration. There's a significant concern to have him properly monitored in the community and to have some mechanism by which the government can take further steps if he violates that supervision.
So I'm trying to figure out how that cuts, though, because again, there's been a proffer to us, and I don't know if you agree with it or don't, but that basically that BOP has tentatively concluded that he does not meet the standard for involuntary commitment and sort of non-criminal commitment. And you both cite that, and you both say it's good for you. Let me sort of give you the argument why that's not good for you, right? Because if he's not eligible for civil commitment, it's not because he's not mentally ill, because we know he's mentally ill, and it's not because of all these. If he's not eligible for civil commitment, the only reason is that the government can't show that he's a present danger to people. And my understanding is that would be the only reason he's not currently eligible for civil commitment. But if you can't show that he's presently dangerous to people, this interest that you're citing about supervised release, I don't know how strong that is, because if you could actually show that he's actually a danger to the community, you should be able to get him civilly committed. And the fact that you can't do that suggests that there's not that much danger. So I guess now I'm going through the purposes of punishment. He's already been incapacitated for 5 years. So to the extent that's already been fulfilled. If you can't show that he's dangerous to the community because you can't civil commit him, I don't know how protection of the public going forward. So, I mean, I understand there's retribution, there are other purposes of punishment, but why doesn't that at least weigh against you? The fact that he doesn't meet the criteria for civil commitment?
Well, Your Honor, the protection of the public is a much broader idea, as it discussed in 3553A, than simply presenting a danger.
Sure.
The protection of the public from possible future criminal activity is a much broader concept than simply protecting the public from physical danger.
But counsel, to follow the logic, unless I misunderstand you, of your argument you just made, if the maximum punishment was 5 years, and we were here 7 years later in the same place here, still going around with whether or not we can restore him to competence, you would have the same argument. You would say, oh, I know he could only get 5 years. He's been here 7 years, but we would lose the opportunity to be able to supervise him, to be able to do that. Isn't that correct? And based on the logic of what you just argued? Because you would lose that right. You said, well, he's 2 years beyond the max, but if you don't do something, restore him and try him, then we won't get a chance to have supervised release and all those things. Wouldn't that be the same logic?
Well, Your Honor, actually, he faced a statutory range of 5 to 20.
And that's why I gave you a hypothetical where the max is 5 years and he's been there 7 years. That's why I did that. I understood that, counsel. I'm saying the logic of what you're arguing would be the same, would it? Would it? You'd be bereft of those arrows in your quiver because you wouldn't have the chance for supervised release. You wouldn't have a chance for conviction. And the second one is that you wouldn't be able to regulate his activities like own a gun, I guess vote, all those other things we take away that you wouldn't have. So you need that, even though he's spent there 2 years over the max. I'm just following the logic of your argument. Is that right?
If I understand your question, Your Honor's question, you're asking about a hypothetical case where.
No, I'm asking right, but I gave you a hypothetical, a counterfactual, and I'm saying based on the logic of the argument you just gave, wouldn't your interest still exist, the ones you listed?
Would still exist, Your Honor.
That's absurd, isn't it?
Your Honor, the standard that we have to look at here is whether the government has acted reasonably during
But you agree that at some point you have to release someone, right? I suspect the government has never met a case where they actually think those standards are, but under the statute, under this entire regime, which implements the due process clause, you have to agree that in principle, at some point, you have to release someone.
Absolutely, Your Honor. Indefinite commitment is not authorized by 42.
And as the chief was saying, in any case, you could make some of these arguments. These arguments, so there have to be a case in which those arguments are overcome by something else, right? You put those two things together, it means that despite the fact that in every single case you can make these arguments, at some point those arguments have to be overcome by something else. You agree with that too?
Absolutely, Your Honor. It's a very fact-specific inquiry. The reasonableness of the circumstances in each case it's extremely fact-specific.
Well, let me ask, counsel. Let me ask this. We are worried that we're getting a little bit far afield here, but we have two unpalatable kinds of choices. One is to involuntarily medicate somebody, and nobody likes the whole idea of doing that. The other would be pushing somebody into trial before they're competent to understand the proceedings. And so you've got two very unpalatable courses, and the district court says the way to get out of this is to take what I think is a reasonable shot in restoring this individual to competency. And all the findings here, whether it be the length of the detention or whether it be the reasonableness of the detention, under our Curbo decision, that's subject to a clearly erroneous standard. And under our cell is clearly erroneous standard. And so the district court is charged under our law with negotiating a path between two very unpalatable options, which is continued detention, involuntary medication, trial of someone incompetent. There are just a lot of very difficult roads here, none of which are palatable or desirable. But the law, as I understand it, charges the district court with a way to navigate this thicket and find a way out of this thicket. And the core of it seems to me is that the district court listened to this physician, Dr. Gravely, and we did not. And he reviewed if he found him highly credible and everything, but I don't understand why this wouldn't be a classic case for deference to the district court. That it's a maze and it's a thicket, and the district court, that's what they exist for, to sort out these sorts of situation where there's a tension between unpalatable choices.
Chief Judge, may I respond?
I assume you agree with all that, right?
Yes, Your Honor. And this is why BOP exercised so much caution in exhausting all other avenues of voluntary compliance of treatment until it finally made the recommendation and until the district court examined those cell factors and came to the finding that there simply was no other alternative. The government is only asking for one bite at the apple, at effective treatment.
Is the government?
It's only asked for one,
Yeah.
excuse me, Judge Wilkerson. You said the government is only asked for one bite at the apple? My goodness, you got the core in this tree almost.
Sir, we're talking about effective treatment, and that has been what has been so elusive in this case. If we can reach an effective treatment, we believe Mr. Tucker will be restored.
And go ahead, Judge.
Oh, I was going to go to different topics. So if you're
Different topic. Well, Judge Wilkerson, you on the same topic. Go ahead.
Yeah, I just wanted to ask whether the government's earlier plea offer is still on the table, the single count with the 5 to 20 year range. Is that still on the table?
Your Honor, I don't believe I can answer that question. I don't believe those options have been discussed recently.
All right, well, is that option going to be put forward to this individual?
I believe the government would always be open to reaching an agreement.
All right, now, if that's the case, would this individual get credit for time served, the time in detention? Although
Absolutely. Absolutely,
so,
Your Honor.
okay, so if you're not ruling out the possibility that the government's original plea offer would be on the table, Judge Heitens had talked about whether the government was prepared to make a sentencing recommendation. And perhaps the way out of this is to renew that plea offer, to have something in the way of a sentencing recommendation put before this individual to take it or leave it, with the understanding that the time spent in detention would be credited to this individual. It may be that, I mean, we've got a terribly thorny situation, but I think maybe the government has a way to break the logjam by renewing its plea offer, having something concrete in the way of a sentencing recommendation, and granting credit for time served. Is that a way to unlock this very difficult case?
If I may,
Sure,
Judge?
yeah.
Your Honor, the government will definitely consider that, but of course, that's all contingent upon Mr. Tucker being competent to enter a plea.
So the questions I had were about a different topic, which is this. You mentioned the district court very carefully went through, and the district court's opinion is very thorough. I guess one thing I didn't see, and this is about the length of detention issue. So the district court basically says, why is this the first time I'm hearing about this? Why is the first time I'm hearing about it? The one time he seemed to very unambiguously say, you're holding me too long, was in August 2019, where he literally said, you're holding me too long. And I didn't see the district court address that. So you read the district court's opinion, it's very persuasive. Like, we've been here the whole time. Why in the world have you literally never said you're holding me too long? And that's really persuasive on its face. But then I think about, did the district court actually say anything about August 12th, 2019, where Mr. Tucker very, very clearly said, you're holding me too long, you need to let me go? What do I do with that?
Your Honor, I believe, and I can check and report with further detail later, but I believe the district court considered that argument, but the argument was not raised in the context of a 4241 violation. It was simply being raised in the sense of Mr. Tucker wanting to be on pretrial release. And so to that argument was later considered actually in 2020 when he filed a motion for release, and the district court found that the standard for release had not been met under the Bail Reform Act.
And then I guess last question, your friend on the other side says, and I want to give you a chance to respond, which is to say, I mean, it's dealing with people who are legally incompetent is really difficult because they're legally incompetent. So your friend on the other side says he does object. He objects in 2019. He objects these few other ways. And yes, there are later times that he doesn't object. But one of the things about being legally incompetent is that you're legally incompetent. And there's a certain perversity of saying that because you're legally incompetent and weren't able to protect your interest, you've now forfeited the ability to protect your interest. What do you respond to that with?
Well, Your Honor, in the Curbo decision, this court did clarify that even a mentally incompetent defendant represented by counsel can be held to have waived any objection to a period of detention. And so we would submit that applies here.
Thank you.
If there are any further questions, we submit.
Thank you, Ms. Niemeyer.
Your Honor, I want to get Judge Heighton's right to what you just ended with. Joint Appendix 499, this is the first cell order by the district court. Footnote 1, he says, you know, this was in September, so a month after the motion was filed. Tucker's counsel stated that he had a pending motion to deny the government an additional 120-day observation period. And then he says the court can't find this motion. But I mean, it was on the docket. And the court says, but you know, to me, this all gets rolled up in the cell thing. So I do think his legal analysis of that, you're right, never happened because he never saw the motion for what it was, which was based on the statutory limits of 4241D. I also want to get, you mentioned the very first arraignment, the Rule 11, Judge Heighton's, and this gets to your point, Judge Wilkinson, couldn't we just get him to take a plea to time served and we all go home, we're all happy? We have been trying to do this to Mr. Tucker for 5 years now, since 2017. I mean, if you look at that docket, the information's filed, the plea agreement's filed the next day, the Rule 11, he was being pushed through the system. You have this whole Rule 11 hearing. We've all been there 100 times, very formal, very this. And
well, what is Mr. Brignat, from your point of view, what is the impediment to what I have suggested, which is that there be a renewal of the plea offer, an offer of a sentencing recommendation, and some sort of credit for time served? It wouldn't necessarily there wouldn't necessarily be an immediate release there, but it would resolve the problem of this indefinite detention for whatever reason, non-compliance, or you haven't raised it, or waiver. It's still not a happy kind of thing. It's but why wouldn't this go a long way to compromising the various interests involved? Because otherwise you're left with a very difficult situation, I think, which is we've got two critical findings, both of which are subject to a clearly erroneous standard of review. Curbo makes clear that reasonableness of detention is subject to a clearly erroneous standard. Sell makes clear that substantially likely is subject to a clearly erroneous standard. So I think you've got a hurdle there, but at the same time, I understand the equities of your situation, which is that this is a very long period of detention, and that's an uncomfortable situation. And I want to know, what is the impediment to having the plea offer renewed, a sentencing recommendation proffered, and credit to this individual for time served? Why haven't the parties come to the table on something like that? What is the problem? What is the resistance?
Two answers, Your Honor, and I cannot put it any better than my client did. Joint Appendix 36, line 11, I'm actually going to plead not guilty. And maybe I'm reading too much into that word actually, but I think that was the first time the system actually asked Mr. Tucker what he thought. He was going to be pushed through, got a good plea, you're 5 years, boom, let's go. Secondly, Your Honor, so first, he's not guilty. I'm actually not guilty. Let's ask Mr. Tucker. He's actually not guilty. I don't think if he were made competent, he'd take the plea. Secondly, Your Honor, he has to be made competent. He has to be shot up with drugs in order to effectuate your solution. I want to just say really quickly, Joint Appendix 304, 100% compliance. Joint Appendix 1392, 1393, the dissolvable pill. The government pointed out that, you know, he didn't take blood draws then. There are issues with blood draws, and that was when he was on the dissolvable medication. And the one blood draw he took indicated that the drugs were at a therapeutic level. And he's still talking about the prison law library being hacked. It gets to your point about the delusions, Judge Gregory. My light's on. I'm happy to take any other questions. Otherwise, we would ask you to, order Mr. Tucker released. And whichever way this panel comes out, I would very respectfully request that it do whatever it's going to do as quickly as possible. I think the government and I both agree, and certainly Mr. Tucker agrees, this does need to resolve one way or another. So we would obviously ask for the relief we want, but whatever relief happen as soon as practical. Thank you very much.
That's just one question in terms of, again, I like your point, like somebody said, finally they asked the person involved, Mr. Tucker, what he thinks. But let me ask you this in terms of, and I'm not obviously for you to go into any kind of confidentiality with your client, but do you really believe, first of all, do you understand, is your understanding that these medications, these medications are suppressive medications? They suppress, it's generally given, but they think it's just going to go like in the brain. Okay, let's go right to the delusional part of the brain and let's suppress. It suppresses a broader base of that, right?
My understanding is it suppresses symptoms beyond the delusions and actually is not as helpful in his case with the delusion.
As a matter of fact, science says the best way is psychotherapy, really, than a pharmaceutical response. That's why I understand why we never talk about the science. We come here to talk about that, but it's psychotherapy is probably the best because a lot of people don't medicate in those situations because they don't like the way it makes them feel. Dull effect, lethargy, all those kind of things. It can lead to a lot of things. Such a whole point is, okay, I don't have delusions anymore, but I'm depressed. Libido, all of those things like that. And so, so you think as counsel that this is going to be like, once he gets to that level, no delusions, he can help you. And again, I don't want you, I'm just, do you think so? Do you think that's because I think you were part of the council, right? That started the whole idea of saying these delusions. There's no question he does have this problem, schizophrenia. But do you think that's going to help?
I think, Your Honor, that I think the delusions have never gone away.
Right.
He's always talking about the FBI, et cetera. I do think that if the delusions had gone away, that seems to be what is impairing him from assisting counsel. Now, certainly, if the delusions go away and it turns out that, we sort of pull away this mental illness and then there's some deeper pathology inside, I certainly wouldn't say, but I do think Your Honor is right to focus on the delusions and particularly on the inability to assist counsel. I think Mr. Tucker throughout these proceedings, and in fact, the very, very first motion to determine incompetency didn't allege that he didn't know what was going on. He understood what he was charged with. He understood the penalties. He knows what a judge is. He knows what a prosecutor is. But when you're talking about the prison law library being hacked and the FBI planting evidence, and it's just impossible. Like, I don't want to bring too much of my own experience in here, but you can't help a client like that, and a client can't help himself.
Yeah.
And under Dudley and under 4241D, that's required. Due process requires that.
Yeah, I think the problem in this case is you'll never be able to get away from the contextual aspect of the delusions because it's the context on steroids. It's the government now actively, no conspiracy theory, trying to put him in prison. I'm not going to mean that in a negative sense because that's your job, but you're trying to give him many, many years in prison. So it'll always feed into his delusion, which is that the government is after me. They try to. So in a sense, it's like telling somebody who's manic depressant, cheer up. They can't cheer up because they're manic depressant. So how are you going to get somebody to delusions that are based solely in the context of the government? And you're trying to get, like you had a great point. In order to get him to the point that Judge Wilkinson raised, I think is a good point about can we work this out? You have to get him to the point where he can, I think counsel, Ms. Niemeyer said the same thing. We got to get him to the point where he's competent to even accept the plea. But you see what I'm saying? So you still in this, I got to depend on that government to do what? You know what I mean? So you never get away from the context of his delusion. So I'm just wondering in terms of Mr. Tucker being the center of our centering moment here for trying to get justice in this case, how do you deal with this?
And I think to the credit of the government doctors and the Butner doctors, they throughout their reports, they've mentioned how they can't really talk to him about the charges because that gets to, he's a represented party and obviously Fifth Amendment issues and all of that. So the very sort of possible talk therapy that could help, if his delusions weren't about his case, if his delusions were his dead grandfather was talking to him or something,
Right.
then possibly there could have that. But I think, and again, to their credit, they understand they can't, but so that sort of means they
Right.
can't, even if, as Dr. Hilke indicated, years of psychotherapy could possibly get him cured. It's not psychotherapy that the Bureau of Prisons, the United States government
Could give, right. They could never be the recipients, the giver, because that, okay, yeah. Okay, that's all I have. Judge Wilkinson, anything further?
I have no further questions.
All right.
Thank you very much, Your Honor.
Thank you so much, counsel. We appreciate your arguments in a very difficult case, and we wish you well. Stay safe. Take care. We'll move on to our next case. Ms. Phipps, when you're ready.
May it please the court. Good morning. I'm Stacey Phipps, Assistant Attorney General representing the North Carolina Department of Labor, Josh Dobson, Commissioner of Labor. We're here today because on September 21st of 2020, a 44-year-old worker and a 48-year-old worker burned to death in a North Carolina paper mill. The fire was ignited by an ISG employee's heat gun making contact with a flammable resin. Following a fatality inspection mandated by state law, ISG was cited for multiple OSHA violations. The North Carolina Department of Labor, through its OSH division, is charged by state statute with ensuring, so far as possible, every working man and woman in the state of North Carolina safe and healthful working conditions and to preserve our human resources. North Carolina OSH has statutory authority to conduct inspections for compliance with safety and health standards. ISG's violation of state OSHA standards resulted in the death of 2 employees. ISG was cited. Before ISG had even filed a notice of contest in the proper state forum, it filed this suit in federal court to circumvent that adjudicatory process. ISG is contesting the citations it received before an administrative law judge. In that contestment, state OSH has the burden of proof for each element of the citation. 1, that a hazard existed. 2, that employees were exposed to that hazard. 3, that the hazard created the possibility of an accident. 4, the substantially probable result of an accident could be death or serious physical injury.
All
And
right, but
five,
please, counsel, what, the district court, you denied your claim of sovereign immunity, and that's the question before us here. And just tell me in a nutshell, what is your argument that the district court was wrong and that you have sovereign immunity here?
yes, Your Honor. The district court held that sovereign immunity did not apply under the ex parte Young exception. And in ex parte Young, it was held.
Just tell me why you think sovereign immunity should apply. I want to get into, to me, that's what's before us. And I want to know why, in your view, you think it should apply. I'm just interested in hearing it.
First of all, the real party in interest here is the state.
That was true in Ex parte Young too.
Thank you, Your Honor. The complaint seeks retroactive relief. The citations here were issued in 2020. And so the relief that's sought is something that would undo those citations from the past and therefore would be retroactive relief. And that would take it out of the ex parte Young exception, which would then have 11th Amendment immunity apply. And related to that is the standing issue. If they're not seeking retroactive relief, then what is it that's going to remove the purported harm of having received those citations?
All right, but the complaint is framed prospectively. In other words, the complaint is framed in a way that ex parte Young appears to authorize. And what they are claiming is, when you read the complaint, it seems to me the gravamen of it is prospective relief, equitable and injunctive relief to have the Department of the North Carolina government cease its practice of rewarding officials for the number of citations that they issue. And they say there's a pattern of behavior going on in state government which contradicts the OSHA statute. And we want to put an end to that. The complaint is drawn in those terms. The prayer for relief is framed prospectively. And so the question is, you need to just tell me, I'm interested in hearing it, why you think this is in reality retrospective relief, which is prohibited under Edelman v. Jordan. Because as I understand it, the fines that were leveled, the $112,000 in citations and whatever have you, that's being litigated in some way in the state court system, whereas the question that's being litigated here is whether in the future the violation of the OSHA statute should continue. And so that just appears facially to be within the framework of ex parte Young. Now, maybe my impression is wrong here. Maybe you can convince me that this is just artful pleading and that in reality it's retrospective, but I need to hear that.
Yes, Your Honor, thank you. Artful pleading is exactly what I was going to say. In reading the prayer for relief directly under subsection G, the last clause says that it would have an injunction from engaging in enforcement activities against ISG. But then the last part of that sentence is including initiating or maintaining administrative proceedings. They are in fact asking for North Carolina Department of Labor to stop administrative proceedings that are already underway because those are related to the incident in 2020 and the citations that were issued in 2021.
But at absolute best, maybe that's an argument that one form of relief they're arguably seeking is barred by sovereign immunity, but that's not an argument the entire lawsuit is barred by sovereign immunity.
Well, that leads into the standing argument as well, because under Lujan versus Defenders of Wildlife, the three items that are outlined for standing.
Well, there's a threshold question though, right? Because if you had filed a motion to dismiss for lack of standing, if let's just say that's the only motion you had filed, and the district court had denied that, you absolutely could not have brought an interlocutory appeal of that. There's tons of cases that say that. So what do you say to the response of your friend on the other side? We are here on pendant appellate jurisdiction under the collateral order doctrine for this. Sorry, we're here. We have collateral order jurisdiction over the sovereign immunity denial. And your friend on the other side makes an argument that says you don't have pendant appellate jurisdiction over the standing issue. You didn't file a reply brief. So what is your response to that argument?
Under Antrican v. Odom, that the issues are inextricably intertwined, because the very factual basis that underlines our 11th immunity arguments also underlies the standing issue.
What factual basis?
In both cases, they're seeking redress for the citations that were issued to them. And if that's the case, then it's retroactive relief. And if it's not retroactive relief, then it doesn't redress their alleged injury in fact, and then there's no standing.
What's your best case for that? I mean, there are cases where we've literally said just because you can appeal an immunity denial doesn't mean you can also appeal standing at the same time.
Yes, I believe under Antrican that they are inextricably related.
So you're not arguing that every sovereign immunity and every standing issue is inextricably intertwined. You're just arguing this particular standing and this particular.
Yes, that's correct. And again, it's because the basis of their prayer for relief addresses retroactive relief. And if it doesn't call for retroactive relief, then it's not really redressing their alleged injury. If the injury, in fact, is the receipt of citations and the prosecution of those citations, which has already occurred, then their suit either addresses it, which is retroactive, or it doesn't address it, meaning that it fails under a test for standing.
Bit of a heads I win, tails you lose kind of situation?
Yes. Returning to the standing items that are listed in the Lujan versus Defenders of Wildlife, there must be an injury in fact. ISG's alleged injury is that it received OSHA citations following a fatality inspection where 2 workers died. ISG describes the issuance of the citation and penalties as its primary injury in its complaint. What they seek is retroactive relief. In their brief at page 17, they say, beginning in September 2020, North Carolina OSHA opened an inspection of ISG, and in March 2021 issued citation items to ISG, and each such citation item assessed a financial penalty totaling $112,000. This is from the original complaint. Redressing this injury would require retroactive relief. The second prong for standing is that the injury must be caused by the conduct complained of. ISG is injured itself. Because it failed to adhere to health and safety standards, it has been issued citations. Here, any purported injury was caused by a lack of compliance with OSHA standards and not by the alleged failure to comply with an administrative regulation about federal employee performance evaluations in the federal code. 2 employees died in a fire at ISG's work site, which triggered a fatality investigation in accordance with state OSHA provisions. Once that inspection began, the citations were issued because health and safety violations were documented. The causation is lacking here. Further on page 18 of its brief, ISG bemoans the number of citation items and says there is no third-party action. It's true that no third-party action injured them because they injured themselves by failing to follow the safety and health standards. The third prong of the test for standing is that the remedy must be likely to redress the injury. What would redress the purported injury of being issued the citations? ISG was cited. That already happened. Withdrawal, rescission, or deletion of those citations as if they were never issued is the only remedy for that alleged harm. That is a retroactive remedy, which takes us out of takes us to our sovereign immunity defense and out of Ex parte Young.
So just as a factual matter, as I recall, did you make a standing argument in the district court?
We did not, Your Honor.
So if we just said the district court correctly held you don't have sovereign immunity affirmed, there's nothing to stop you from moving to dismiss for lack of standing on precisely this ground and to let the district court consider that argument in the first instance?
Well, we made jurisdictional arguments and
Sure, but my question is whether you made the standing argument you're currently making right now before the district court.
We have consistently made various immunity.
Oh, I certainly agree with that. But I guess I'd say under 12B1, you can make a jurisdictional argument at any time. So there's nothing that would stop you from making these precise same arguments to the district court.
Right. The Steel Company case versus Citizens for a Better Environment says that jurisdiction is a threshold matter, and that it can be raised at any time. As you're aware, it can be raised sua sponte by the court. And that's part of our argument that it's inextricably intertwined. Further, as stated to the district court, there are other avenues that the parties have that could address this. The redress they seek be given by other forums. They are, as was mentioned, proceeding with an appeal or a contestment in state court of the actual citations themselves. And they are also, they did not avail themselves of the CASPA process, which is the Complaints Against State Plan Administrators. And that's contained in the record as an exhibit to our answer, which is at page 147. Now, the magistrate focused on the may language of CASPA, saying that someone may initiate a complaint through that forum. But there is, however, no other statutory authority or CFR authority that allows for a private action or an action in federal court if you have a complaint about a state plan. I believe I'm over my time now. Glad to answer any questions.
Thank you, Ms. Phipps. Mr. Vance?
Chief Judge Gregory, and please the court. Travis Vance with Fisher & Phillips. We represent Industrial Services Group doing business as Universal Blasco. I'll refer to them as Blasco for ease of reference. The district court's order denying defendant's motion to dismiss based on sovereign immunity should be affirmed because Ex parte Young on all fours provides that defendants are not immune from Blasco's suit. Blasco has sued two individuals who are state officials in their official capacities for prospective, injunctive, and declaratory relief. Defendants are not afforded the protection of 11th Amendment immunity due to their ultra-virus enforcement activities. Thus, Ex parte Young, the Ex parte Young exception to sovereign immunity applies. This court's review ends with that determination.
So there are a couple exceptions to Ex parte Young, right? There's like the Coeur d'Alene, this is about real property and it's going to screw up real property. And there's Seminole Tribe's intricate remedial scheme exception. But it's my understanding that none of those arguments were made here, that like an exception to the Young exception applies.
That's correct. Judge Heitens never saw that in the pleadings. No, none of those arguments were made. It's very straightforward. It's just like Ex parte Young. In that case, of course, it was railroad rates being changed by the state, and the railroad sued the state to stop that action. And they said essentially that the state officials did not get the cloak of immunity because they were violating federal law. That's exactly what we have here in North Carolina. You have state officials. We've sued them in their official capacities. They have violated federal law, which we've noted, which is Section 8H of the OSH Act. And because they are violating federal law on an ongoing basis, they are not given the cloak of sovereign immunity, which is exactly what Ex parte Young.
All right, you're not contesting, counsel, you're not contesting the fact that on remand, the state can raise the standing argument, are you?
No, I think jurisdictionally, that can be raised at any time if there's no.
Right, but I mean, they can raise they can raise on remand the fact that they that these citations or whatever the behavior of the North Carolina Department didn't cause the injury that you complain of, that what caused the injury and what in terms of the citations was the fire and the obligation that North Carolina had to investigate safety violations that may have caused the fire, and that it didn't have anything to do with OSHA quotas or how, in fact, OSHA evaluates its employees by the number of citations. But this basic issue of causation is open to the North Carolina on remand. You would concede that, would you not?
Yes, sure. I'm sure that there will be issues of standing and other matters on the merits with respect to this matter once it's remanded with instruction or this district court's decision is affirmed. But if you look at the Verizon Maryland case, which I would invite the court to look at, the district court relied on it. It's on all squares, I think, very instructive. It's a Supreme Court decision. Justice Scalia wrote the opinion, very instructive. But there, Justice Scalia says that in determining whether the ex parte Young doctrine avoids an 11th Amendment bar to suit, a court need only conduct a straightforward inquiry into whether the complaint alleges an ongoing violation of federal law and seeks relief properly characterized as prospective. And that is exactly what Blasco has done here. And further, the Verizon case, it goes on to say, in that case, it was the state version of the Federal Communications Commission. They had issued an order telling Verizon Maryland to pay a sum of money, and Verizon Maryland filed an ex parte Young action. It actually came through the Fourth Circuit, and the Supreme Court decided that it could go forward under ex parte Young. And in the decision, the Supreme Court says, very instructive, it says in evaluating that claim, it may or may not be true that state contract law and not federal law, as Verizon contends, applies to the disputes regarding the interpretation of Verizon's agreement. But the inquiry into whether a suit lies under ex parte Young does not include an analysis of the merits of the claim. So here, what Blasco has done is it's got a complaint for injunctive and declaratory relief that is solely prospective against two state officials in their official capacities. It meets on all fours ex parte Young. The analysis ends there. You don't go any further on the merits. With respect to standing,
does your prayer for relief contain any mention of monetary relief or relief from the $112,000 that was levied in citation?
Absolutely not, Judge Wilkinson. We did not seek any money whatsoever. And the citations are being contested through the state, OSHA review commission. And that's
so the retrospective relief, in your view, is being debated and conducted within the state system.
Well, the state system is we're contesting the citations, and so the federal lawsuit we filed
within state administrative law, within the state administrative system, right?
Right, and I'm not necessarily consider that to be retrospective, Your Honor, but we have contested them under that system because we have an obligation to do that within a certain period.
Well, but there's a lot stronger case to be made for the if you're contesting the monetary award of the citations, that's retrospective. You may not agree with that, but there's a lot stronger Edelman v. Jordan argument to be raised with respect to that. But what I understand you're telling me is that in the prayer for relief in your complaint, it's framed purely in terms of injunctive relief that pertains to future conduct on the part of the Department of Labor, and whether it's in conformity with the federal statute, and specifically the prohibition in the federal statute against using performance evaluations by the number of citations issued. That's what I understand. You may not win on the merits. I have my real questions about that, particularly in view of the causation here and whether the Department of Labor has anything to do with it. I think all they're doing is investigating a fire, and I'm not sure that has a darn thing to do with the policy of the DOL that you take exception to. Your only point is that's for remand.
That's correct, Your Honor. And if causation has to be decided on remand, that's certainly something we would talk about. But here, there was an accident, very tragic situation where two gentlemen of another contractor passed away, and there were citations issued. Now, we believe that some of those citations were issued because of this illegal incentive program that North Carolina OSHA has, but that will be resolved at the state agency level. What we have here,
I understand all that. There is an irony here, and that is that we're dealing with the tragic death of two individuals, and that would seem to be something that you bear responsibility for. And yet the North Carolina DOL is the one that's being called on the carpet for a policy that, in my view, has only an attenuated connection with what was happening here, which was to investigate the results of a very sad situation. I mean, I understand your ex parte Young argument, and in a technical sense, when you look at the prayer for relief in the complaint, that makes a certain amount of sense. But it is just very troubling on another level that here the two people died because of your quite possibly because of your safety violations and inability to protect these employees. And yet here the Department of Labor is the one that's being called on the carpet. And, I understand the ex parte Young argument. As a technical matter, it's a good one, but it doesn't sit well with me in terms of what is happening here and whether the accusations are being leveled at the wrong party and over something that you, I think, may well bear some responsibility for. I don't want to jump to conclusions on it, but the OSHA was doing what it's supposed to do, which was to try to get this a situation where fires and tragedies of this kind that claim workers' lives are to be prevented. And they're looking into that and they're investigating it. And here they're being called on the carpet for what seems to be an unrelated policy. It doesn't sit well with me. But at the same time, I understand in a technical fashion what the ex parte Young argument is. It's set forth in the prayer for relief. Maybe ex parte Young can be artfully pled. Do we have a doctrine that it may not be an exception to the ex parte Young exception, but how about cases that indicate that ex parte Young, that anybody can construct a complaint in this way and be in conformity with ex parte Young? Is that artful pleading?
Well, Your Honor, but the issue here is that North Carolina OSHA has a policy that violates federal law, and that has nothing to do with this particular accident per se, because the accident was tragic, and there are forums where the families will be made whole to the extent possible under the law. But
you can't make people whole for something like this.
I understand. And I don't disagree with you, Your Honor. It's a very tragic situation. But what we have here is Blasco was cited, and during this process, we have discovered that North Carolina OSHA has a program where it at least evaluates its inspectors on how many citations and inspections they conduct. And that is illegal under federal law. And so it is that unfortunate accident in 2020 is an issue here, but also at issue is North Carolina OSHA through its two officials going forward, incentivizing its inspectors to issue citations. And that's going to apply not just in this case, but in every case where there's an OSHA inspection in North Carolina. So I'm sure this court does not want to uphold a decision or make a decision in this case where North Carolina OSHA can say, go out and issue 10 citations every time you go to a work site. What we want is North Carolina OSHA to be told, go promote safety. If an employer's doing something wrong, then cite them. If they're not doing something wrong, then don't cite them. We want them to call balls and strikes. We don't want them to expand the strike zone. So,
and so are we in a situation where after every tragedy and every loss of life, any subsequent OSHA investigation that results in the issuance of citations is going to be grounds for a lawsuit on the assertion that it was in violation of this federal statutory provision. So, I mean, what does that do ultimately to OSHA's ability to carry out a larger congressional mandate, which is to help safeguard the safety and health of workers? Because we're at the situation now where if your argument prevails, and again, on a technical sense, I understand it, but anytime OSHA looks into a national tragedy, and anytime it issues citations, an automatic lawsuit follows, which is that they have violated this particular statutory provision. Even what they've done, even when they've acted in accordance with what Congress wanted them to do in terms of workplace safety. So what's the end game here? Are we in a situation where any post-tragedy, any investigation into a serious tragedy is going to result in a lawsuit against the North Carolina Department of Labor and the and OSHA itself?
Yeah, Your Honor, it's a good question. The end game here is that North Carolina OSHA just needs to stop it. They need to stop incentivizing their inspectors in violation of federal law. And the end game is achieved by this lawsuit. This lawsuit provides the injunctive relief for Blasco and employers in North Carolina to stop that. And once they stop that, then there's another tragedy that happens in North Carolina. There's an OSHA inspection. There's no lawsuit because North Carolina OSHA no longer incentivizes their inspectors to issue citations. And this lawsuit's going to stop that. That's the end.
But why can't you bring this same lawsuit anytime that OSHA, anytime that there's a fire or a flood or an industrial accident, OSHA goes to investigate the industrial accident. A complaint is framed in terms of prospective compliance with federal law. So are we not, I want to answer to my question, are we in the position of saying that every time OSHA investigates a tragic industrial accident, that it's going to be faced with a lawsuit on a complaint drafted in this fashion?
Your Honor, the way we've drafted this complaint meets the threshold question of ex parte Young, and it should go.
All right, but why couldn't this be just a bit of boilerplate?
Yeah,
I want to know why this doesn't go down the road and just appear. You can roll out a complaint as a matter of boilerplate against OSHA for any investigation into an industrial accident.
I don't think this court would want any employer to face a situation where you're going to go up against state officials that are violating federal law. So to answer your question, Judge Wilkinson, going forward, if an employer was inspected or cited by North Carolina OSHA, they could file this lawsuit because the purpose of the lawsuit is to get North Carolina OSHA to stop violating federal law, just like ex parte Young was to stop the commissioners from lowering the tax of the railroad rates.
Well, one could look at the purpose of this lawsuit as an attempt to shield you from citation and investigation as a result of a tragic accident.
Well, Your Honor, it would not be if North Carolina OSHA stops violating federal law. If they change
You're
the-
assuming a conclusion.
well, if they stopped this incentive program, then there would be no violation of federal law, and so therefore there would not be any future lawsuits. And hopefully, this lawsuit stops this program, and therefore there won't be a need for future lawsuits. But any employer could have filed this lawsuit, and just it was not raised in the briefs. It was not a notice of appeal, so standing is not before this court as our position as noted in briefs. But if Blasco after have been inspected and cited, doesn't have standing to bring this lawsuit, then it begs the question, who does?
Mr. Vance, may I ask you a question? It's like the old adage, an ounce of prevention is worth a pound of cure. After you get the relief, the prospective relief you say you want, if they find statistically that places, because the idea is you want to prevent, we don't want to give citations posthumously, as here, right? So if they find that places that have been inspected and their citations tend to be ones where there are no accidents or very low, but they find places where there are very few citations, there are more instances of injuries and deaths. Would that be illegal? Say when they say no, we're not basing it on incentivizing the fact of citations. We are looking at the fact that it's saving lives based on our statistical type thing. But I'm just looking at what it would look like for the topic of labor. And going back to Judge Wilkinson's point, then you would say, wait a minute, you're writing a lot of, but they said, no, we write them not to incentivize because we have found that there is a connection with writing them and very few violations. And the lower the number, the more later the tragic deaths occur. So you would say that's incentivizing because what? You keep their job, they get a bonus. What does it look like if you win your injunction?
Good question, Chief Judge Gregory. So if you just look at the OSHA Act, it says this, that they shall not use the results of enforcement activities such as the number of citations issued or penalties assessed to evaluate employees directly involved in enforcement activities under this act or to impose quotas or goals with regard to the results of such activities. What we want are for OSHA inspectors to go out and issue citations if there's a violation of an OSHA standard. And if there's not a violation of an OSHA standard, they don't have to issue a citation. And if they go out and they find 15 employers that don't have any violations, the inspectors should not be dinged. They should not get a bad evaluation because of that. They are simply looking for violations of standards and they want to keep people safe. South Carolina OSHA has 20 to 25 inspectors. It's another OSHA state plan. North Carolina has over 100. And historically, my understanding is that South Carolina has had better injury and illness rates. And what that tells me is that South Carolina, which does not have this quota, is looking to protect workers. And that should be the primary concern of employers and North Carolina OSHA. Go out there and write citations when they're warranted. But if they're not, an inspector should not be pressured because the evaluation forms they've already produced, in this case, specifically show, here's the number of citations we're going to evaluate on how many you've issued this year. And that's illegal. And it doesn't promote worker safety. To your point, Judge, we want workers to be safe. If there's a citation, then cite it. If there's not a citation, then don't cite it. Just like a police officer that's watching speeders going down the street, if they see 10 speeders, then pull them over. If they don't see any speeders, then don't meet a quota that's not there. And just one last.
You think that's the way it works with state troopers?
No, it would be illegal. So for analogy, if just is talking about due process in an injury to Blasco, if a food safety inspector went into a restaurant and they had a quota that says you had to have a C average on your inspections. They go into bookbinders, which I went to last night. Fantastic. They go in there and they give bookbinders a C minus because they have to meet that quota. What do you think happens to bookbinders? They're going to start losing customers. Same analogy here. If Blasco gets these citations under this illegal statute or illegal program under the OSHA, it's going to impact Blasco's business opportunities. It's going to impact how people view them in the public, and it's a real injury. And that's our position here. Is
And you think that injury exists no matter how meritorious those incentivized citations were?
Well, no, if they're meritorious, it's
No. You said the problem is being incentivized. We haven't got to the point whether or not incentivized. Well, it's like the state trooper. Incentivized theoretically doesn't mean that they weren't speeding. You see, that's not the same thing, right? Because you're saying under your what happened is no matter how meritorious these citations are, the violation exists solely because of numerosity, not right, correct?
It's the evaluation system, Your Honor.
I know
That's
right.
what violates the federal.
And so it doesn't matter how meritorious the citations were, correct?
That's why we want to stop.
Right. I'm gonna make sure you're right. Right. It doesn't matter as long as you illegally they incentivize by saying, you need to write at least 20 in the coming year.
That's right.
So if that's a violation because it's incentivized, but that has nothing to do with, notwithstanding the fact that everyone was meritorious and it perhaps saved lives. Right.
We want to keep workers safe, just like I think the agency does, but employers can't be subject to an enforcement system that encourages the inspectors to write citations when they're not warranted. For those reasons, Your Honor, we respectfully request that the district court's order denying the defendant's motion to dismiss based on sovereign immunity be affirmed.
Thank you, Mr. Vance.
Thank you, Your Honor. ISG has set forth a lot of analogies that are based on the fallacy that the federal provision applies to a state plan state.
Let me ask you a prefatory question. It seems to me that you have a very good argument on standing and under the causation prong of standing, that the injury here was not caused by any sort of quota system. What was caused by the fact that OSHA had an obligation to investigate a fire. Given the strength of your argument with respect to causation, why didn't you just raise the question of standing ab initio before the district court, rather than waiting up here and trying to shoehorn it into an ancillary issue on an interlocutory appeal? You're going to run into problems where you start tacking on ancillary issues, and it goes against our Antrica precedent and everything. Why wouldn't the way to litigate this case be just making a straightforward standing argument before the district court saying that the causation prong of standing is not met under the facts here? I don't understand why this case is being litigated the way it has been.
Your Honor, I can't fully answer that question. I had a supervisor. Everyone has a supervisor, and I have a client, and some of those decisions are, as they say, above my pay grade. But the position that we're in now is, despite ISG's protestations that they're not seeking monetary damages, in fact, they are. In their own complaint, in the prayer for relief, they say that they don't want the maintaining of administrative proceedings. So if the North Carolina Department of Labor stops the proceedings against ISG, guess what? They don't have to pay $112,000. So just because they don't use the term monetary relief in their complaint doesn't mean they're not seeking monetary relief. Also, they are trying to bootstrap this to the underlying OSHA case. They have in their own facts repeatedly on page 22 of their complaint, they outline the specific enforcement activities against ISG. They talk about the fire. They talk about the employees who died. So they are bootstrapping this whole argument about the purported applicability of a federal provision to the underlying OSHA case. They chose to go that route. And if they are in fear of future violations that may occur, I guess they're saying that they're going to continue to have violations because otherwise there wouldn't be any issued. So I think that the points have been made, and Mr. Judge Wilkinson has correctly identified where this is all headed. I'd be glad to answer any other questions.
Thank you, counsel. And thank you both for your arguments. We appreciate those, and we wish you well. Be safe. Thank you. We'll proceed to our last case for the term.
And Your Honor, may it please the court. My name is Claire Rauscher, and I have represented Shannon Drake since July of 2016. The Hyde Amendment was enacted for criminal prosecutions just like this one. What happened during the prosecution of this case warrants a remand of this matter and assessment of attorney's fees. The trial judge used a legal determination that was incorrect, as well as abused his discretion based on all the facts that occurred during the prosecution of this case. And the key here are the facts, the overall facts over the prosecution that occurred over a 2.5-year period of time. First, the government misled not only Ms. Drake, her lawyers, the grand jury, and the judge in this case about whether she was in fact a witness or whether she was a target or a subject. In fact, this misrepresentation was so egregious that the North Carolina State Bar has filed a complaint against the prosecutor in a very unusual action. During the Ms. Drake was subpoenaed twice before the grand jury. Both times she was told by the government that she was merely a witness and not a target or a subject of the investigation.
Counsel, didn't the district court make a finding on that very point that there was she was told that, but the district court said there's no intended misrepresentation here and no prejudice to Drake, but the district court, the Hyde Amendment terms speaks in terms of vexation and bad faith, and the district court made a finding here that there was no bad faith, that there was no intended misrepresentation. So we have a finding that seems right on point in terms of the standards of the Hyde Amendment, and I wonder how we overcome that.
Well, you overcome that, Your Honor, by looking at the entire and all the facts. And in fact, if you look at the record of what the judge actually said, quote, during the hearing, he said this was very troubling. He also said, in fact, in the footnote in his opinion, that he was unimpressed and was going to take it under advisement as to what he was going to do about it because he was misled by a filing by the government. Now, we don't know what, if anything, the judge did, but I would say to the court that when you look at the overall circumstances and what the judge said at the time, it's clear that there were problems. But the bad faith part of this has to do with the overall facts. And I'll go over that, Your Honor, shortly about all the different things that happened that shows the bad faith of the government. So as I said, there are numerous factors, and here is one of them, is the misleading of the jury, grand jury, Ms. Drake, her lawyers, as well as the court. The next factor that's important is during the case throughout the prosecution, the government told the court, defense counsel, that there was a witness before the grand jury, CG, that was clearly the person who was important and was essentially going to make out this case. And they told the judge in pretrial, they told the judge this person was a witness on the witness list. In fact, they even said in their trial brief that this person was going to be called.
Well, if the judge felt as badly and misinformed and misled as you suggest, it was open to him to award attorney's fees, but he declined to do that. And he made findings indicating why he declined to do it. How do we look behind those?
Well, Your Honor, essentially, he made an incorrect legal determination. He was using the untested testimony of a grand jury witness to justify the fact as to denying this petition. And if you look at the evidence that CG testified in front of the grand jury, there's absolutely, not only did she not testify, there was absolutely no corroboration as to what the judge was relying upon during this. I mean, there was no opportunity to cross-examine. It was a grand jury, but the judge made that legal determination to warrant and give credit to that testimony. And that's where the problem is. That's where the judge made the wrong legal determination by relying on that in his opinion.
Would you continue you're about to say about what was said about CG? And so we have to, we give a lot of, as you know, the standard is tough in terms of deference to the district court, but we do look at facts to see whether or not it's inconsistent. So what are you saying that the government said about CG in respect to being the key witness or grand jury? Or what do they represent to the court?
Well, they represented to the court that when and there are many pretrial motions in this case, and they represented the court the importance of her and her testimony. But they never called her. And here's the interesting part is the lack of corroboration of what she said, right? They didn't call her, but they could have brought in other evidence. One of the things she said was that Shannon Drake was told to shred documents by the co-conspirator, co-defendant, Doug Currier.
Right.
CG testified that Drake told her that she asked CG to shred documents as well as another employee.
These were proffers by the government, what she had said and would say, correct?
Right.
All right.
That's what she said at the grand jury.
Now, how do we know that the court was led by those proffers, a witness who never testified and in fact didn't go to the grand jury? How do we know that the judge was persuaded or sufficiently or significantly influenced by that in terms of denying your motion? How do we know that?
He said that throughout his 33-page opinion.
Right. Okay.
Over and over again, he said that he credited that testimony.
Well, not credited that testimony. He granted your Rule 29 motion, but the question isn't whether your client was guilty or not guilty, whether the government should win or not win. The question is whether the government's case was the three words that the Hyde Amendment uses. And the district court said they had this witness, and this witness testified before the grand jury, and that is relevant to whether the government's entire prosecution meets the high standard under the Hyde Amendment. What's wrong with that?
What's wrong with that is the government has a duty to conduct an investigation. You know, Your Honor, if you're allowed to put witnesses in front of the grand jury to rely, one, on the indictment. And as we know, the case law, Claro and Isaiah says you can't rely solely on an indictment for the probable cause, right?
Totally
The
agree. Can I ask you that? Because- Go ahead,
Excuse
Judge
me. No, go ahead, please.
Oh, I just had one question. You say repeatedly in your brief something you just said, and I just wanted to ask you about that. You say that you can't rely solely on the fact of an indictment to show that it was substantially justified. 1000% agree with that. The part is, I don't read the district court as having said that. And so could you just identify where you think, because you assert it over and over again in your brief, where do you think the district court said, I am relying solely on the fact of an indictment in denying fees?
In his opinion, the judge says several times that the testimony.
But I'm just looking for the best one. What I just told you I am skeptical that the district court ever said that. So what is where you think the district court most clearly says, I am relying solely on the fact of an indictment to deny fees?
He doesn't specifically say the indictment. He specifically says the testimony of CG. And that only occurred in front of the grand jury. So he is relying on that. That's really.
Well, if he's relying, if it just to follow up on what my friend Judge Hyten said, if he's relying purely on the grand jury or whatever, how were you able to get a Rule 29 dismissal? Because in order to grant a Rule 29 dismissal, the district court would have had to look at all of the evidence in the case. To me, I think you were lucky to get this Rule 29 dismissal. District court said it was a close case, and a lot of it. A good case could be made that Drake was an employee at Grand South who facilitated the scheme, or Harrison's scheme, to defraud the IRS. You were really lucky to get a Rule 29 dismissal. And now you want, on top of that, to get attorney's fees and to overcome the district court's view, which I agree with Judge Hytens. I thought the district court looked at this case as a whole, in its totality, in the round, and not just at the indictment. But you were lucky. You should have taken solace in your good fortune and proceeded home.
Well, Your Honor, we certainly were pleased when the judge did that. I'm not going to deny that. However, when you look at it, and I've said this over and over again, you have to look at the case as a whole. The key here is, and there was no dispute as to what Shannon Drake's role at the bank was, and that she was assigned these accounts by Doug Currier, that she administered the accounts, that she did all of that. There was no denying that.
Well, there was, and as the district judge says in arguing that you're viewing the issue too narrowly, the district judge also says there's no dispute about two other things. There's some real bad stuff going on that is unquestionably illegal, and that your client handled some of the bad materials. And so, as I understand what the district court says, literally the only question is, did she know what she was doing or not? Because there's no, I guess another way to say it is, I think the district court said there's very little question that your client committed the actus reus of the offense. The only question is whether she had the mens rea. Is that right?
That's correct.
And it's very clear that there are other people who had the mens rea. Not saying your client had the mens rea, but there were other people who had the mens rea.
That's correct.
And so I guess could you respond? One of the things the district court said about your argument that I found sort of persuasive is to say it's sort of artificially bifurcating the issue down to the only actually disputed question and just pretending that the rest of it doesn't matter. The district court said, when we're assessing whether the government's case is substantially justified, we have to also include there clearly was bad stuff going on in the bank, and your client very clearly was handling some of the bad documents. Oh, and third, she was very clearly working with someone who had also committed a crime. And we can't pretend that none of that exists for purposes of whether the government's case was substantially justified. I guess I'll say I share with Judge Wilkinson that My reaction was that your client was fairly fortunate to get a Rule 29 dismissal in this case. So what is your best response to that?
The response to this is that there is no evidence that not only Ms. Drake, but anyone else at the bank other than Doug Courier and Greg Harrison, who own the accounts, knew that there was anything wrong with these accounts. There is absolutely no evidence. Throughout the trial, they brought in employees and they would.
But wasn't part of the problem there that the district court suppressed some of the witnesses that they wanted to call, right? There were people who were going to testify. This was some really weird, out of the ordinary stuff, which could give rise to an inference that your client knew what she was doing was wrong, but the district court suppressed that. But I mean, at least the First Circuit in the Knott case has said, in assessing whether the government's case was substantially justified, we can consider evidence that was suppressed by the district court. So why, in making that whole determination, I mean, the district court was very candid in a number of respects. The court even said, I might have gotten some evidentiary rulings wrong, right? And so what do I do with that?
Well, my response to that would be, I think that some of that was inadmissible.
I understand you think that, and the government thought the opposite, and the district court agreed with you.
Exactly. I have to deal with the record as it stands. And the judge may say, oh, gee, maybe I should have let that in. But the judge didn't let that in. And we're looking at the record as it stands.
No, but Knott says, I mean, I guess, are you telling me that you disagree with Knott? Or so Knott says you consider suppressed evidence in deciding the Hyde Amendment question. Do you disagree with that?
Well, it depends on what the suppressed evidence is.
Well, the testimony that some people would have said this was extremely weird stuff, deeply out of the ordinary, which could have allowed a reasonable jury to conclude that your client knew that what she was doing was wrong.
My understanding is the testimony would have been that these were different, that the forms were different, and that things were handled in a different way. But there was not going to be any testimony that it was that these people thought it was wrong, or that the judge wouldn't let us use the word illegal, but inaccurate. That did come out, that no one said that it was inaccurate. It's a small bank. There was evidence there was no training. Everybody did their job. And that's what happened here. I mean, everybody did their job. Shannon Drake did what she was told to do, and there's no evidence, especially the individual who worked on those accounts with her.
Before you sit down, I have a question about discovery. Are you aware of, other than that 1997 case right after the Hyde Amendment was enacted, are you aware, I didn't see cited in the briefs, any case where a district court has actually awarded discovery on Hyde Amendment issue?
In the Gardner case.
Is that the 1998 Oklahoma decision?
That is correct. That is the only one. And, and it's unusual. The statute says you can have ex parte in camera, but it's never been awarded. I mean, as certainly has been said over and over again, there's a large obstacle to overcome many of the case law and various things that have happened in this case, but I'd submit to the court.
Counsel, I just want to say that if you represented MS Drake at trial, you did a very good job. And we were talking about it. You were talking about it being a small bank and everything. And I wonder, on hearing that, I said, well, when you got a small business or a small bank, people know what's going on. They know what's going on within that bank, and the relationship between Harrison and Drake was sufficiently collaborative that it's hard to believe that she didn't have some inkling of what was happening. But all I can say is, if you were counsel at trial, you did a very, very good job looking at the whole facts of this case, and getting that Rule 29 dismissal. That was a really close, near thing, and you won it. And that's much, in my view, that is much to your credit.
Well, I appreciate that. Thank you, Your Honor. My time's up.
Thank you. Mr. Knapp.
Thank you. May it please the court. Greg Knapp for the government. The court will not be surprised to learn that I take no issue with the observations made today from the bench that Ms. Drake was perhaps lucky in getting the Rule 29 motion for a judgment of acquittal. But of course, that's not the issue that the court needs to decide, whether or not the district court actually got the Rule 29 motion correct. I think there are several observations, several findings that the district court made in the course of granting the Rule 29 motion that defy any conclusion that this prosecution was vexatious or in bad faith.
Can I ask just a threshold question that I didn't see? What is the status of the bar discipline complaint?
It's pending.
What does that mean?
I don't know. It's a stayed. I looked at the complaint. There's an answer filed. It's stayed. Beyond that, I don't know. And as for those findings by the district court, one was that although, yes, I am granting the Rule 29 motion, I find this to be a close case. And if it's a close case, in other words, if the government's evidence at trial was almost enough to prove guilt beyond a reasonable doubt, even as to intent, then it can't be said that the prosecution was groundless. It can't be said that the prosecution was so vexatious and lacking probable cause.
Could have been brought in bad faith, though, right? The analogy I keep going to here is Rule 11, right? So Rule 11 similarly says you can't bring things that are meritless, right? And you can't bring things that are objectively unreasonable. But Rule 11 also says you can't bring things in bad faith, which to me suggests that there can be something that's not frivolous, but still in bad faith. So the fact that it's a close case doesn't mean it wasn't in bad faith. So what do you say about that?
Absolutely. And then jumping to one of the other findings by the district court at the Rule 29 motion, the district court went out of its way to commend the government for its handling of its evidence and for its candor and professionalism in presenting its case. Now, if the district court really felt that it was misled, as was suggested by my colleague today, that would be a very strange finding to make. And on that point, I would like to dispute that claim. I mean, there is no statement by the district court that it felt misled by the government's presentation of this case.
What about the star witness CG that you had watched it quite a bit?
I would simply respond that there's been no showing that the government acted improperly or in bad faith in the handling of that witness. The government intended to call her, but then based on developments shortly before or during trial, the government decided not to. And we can infer from the record that the reason was related to potential credibility attacks. And that's
and that the district court would not give you a ruling on the scope of cross-examination question? Was that part of it? That you made a motion to limit the cross-examination that the district court had not ruled on?
That's part of it. Yes. The record does not fully disclose the reason why the government chose not to call CG.
But it's on the record that you'd filed a motion to limit the cross, and that it's on the record that.
And so, to an earlier point, it was observed that regarding evidence that's excluded, if there's a good faith argument that the government has for admitting that evidence, that's properly considered as part of the Heidemann analysis. And the district court made that observation during its Rule 29 motion. That also is instructive with respect to the treatment of CG, because in this motion that the government filed in limine regarding the scope of the cross-examination, the government cited cases from this circuit holding that these collateral issues that were expected to arise regarding an apparent violation of the bank's sexual misconduct policy could be properly limited. And so the government had a good faith basis for moving forward with its witness, but appropriately limiting the inquiry of cross-examination on these side matters. Now, as Your Honor has observed, that was not fully resolved, but the point is, it's a good faith argument. The government had a good faith basis for proceeding forward. And if there's a good faith argument, there cannot be recovery under the Hyde Amendment. I mean, the Hyde Amendment only reaches cases in which bad faith so permeates the prosecution that it can be found that the government's purpose in bringing the case was improper. And there's no remote suggestion of that here.
You take CG out, what is the real best evidence as to mens rea?
Excluding CG, just for purposes of argument,
Sure.
we have the fact that Ms. Drake was the account executive assigned to handle the nominee accounts.
That's her job.
That is her job.
Okay. Go ahead.
That's
her
it's
job.
her
You can't
job.
wait a minute. Boy, I'm gonna cut you off, but go ahead. But if you're citing things as her job, you can't remove yourself from your job. So I'm talking about, okay, go ahead. Maybe just the job is it. Go ahead. She
That
was
is
an
not
exec. Go ahead.
I'll agree with you in part. It's the job of account executives to make these types of entries.
Right.
It's not the job of an account executive to use nominees to conceal the actual beneficiary's interest in this nominee accounts. And so moving to the other evidence, we have the fact that Drake was working with Collier, the convicted felon in this case, one of the architects of the nominee lending scheme. We have the fact that Shannon Drake also not worked only internally with Collier, but also worked externally with Harrison's company. And she communicated directly with Harrison's employees regarding which nominees Harrison wanted to use to cover his interest in these nominee accounts, to cover various invoices, cover various factoring advances that benefited him. So this is not a case where Ms. Drake is just duped by Collier, is just handed a set of false invoices and told to enter them mechanically. She is involved in the process of determining which nominees will be used to conceal his interest. Other evidence, the fact that she then, consistent with those communications with Harrison's company, made what the district court found to be materially false entries in the books and records. Now, all of that, and that's before even getting to CG, consistent with your question. And so all that evidence, at a minimum, it shows that she has to know that Greg Harrison is the real beneficiary behind these nominee accounts. And it also gives the government a good faith basis at a minimum for arguing the next inferential step, that she also knows that by using these nominees, she is facilitating Harrison in getting around the bank's lending limit that's applicable to a singular borrower, and thereby facilitating his bank fraud.
And could you now add, I want to still leave CG out of it, but these witnesses that you wanted, there was some discussion about what exactly these witnesses that the district court suppressed would have said. What would that have been?
One witness who worked for Harrison's company would have testified as to the unusual nature of the factoring arrangement that Harrison had with Grand South Bank, as opposed to other factoring relationships in her experience. I'm blanking on that name. It was either Kathy Miller or Angela Holland, I forget which one, but an employee of Harrison's company. Then also bank employees, Cindy Ayers and one other.
And I don't need the names. What is your understanding of what they would have said?
They would have testified also that the wire forms that were used to advance funds on Harrison accounts were atypical, they were unusual, and that it was unusual to have so many names assigned to a single account. During trial, the government proffered some of that evidence, the district court excluded it, we moved on. If there are no other questions, I will be glad to see the rest of my time.
All right, thank you, Mr. Knapp.
Couple things to respond to here. When the court was talking about the mens rea and some of the other evidence that came out, there was no evidence at all that Shannon Drake knew anything about lending limits. There was no evidence at all that she had any access to any of the actual loan agreements that were signed between Harrison and the nominees. There was evidence in the case that everyone in the bank knew that Greg Harrison owned the nominee companies. So the fact that money was going to Harrison was not a surprise. In fact, the wire room had that form that Mr. Knapp talked about, and they said that, yeah, it was an unusual form regarding others, but they had no reason to believe otherwise, that sending the money to these various places was a problem. So, I mean, the key here is everyone understood and didn't think that there was anything wrong with what they were being told to do. Did Collier and Harrison know? Absolutely. But here's another key factor. The co-conspirator, co-defendant, and supervisor of Shannon Drake was their big star cooperator. Did he, in his testimony, ever say anything that he told her to shred documents, that he let her know that this was improper? Was there anything that he testified about? No. All he said was that she was involved and she was the account manager and took over the accounts and did all that work, and that she was a hard worker and diligent. Absolutely no evidence that he did anything or testified to anything that she knew what she was doing was wrong or had the criminal intent. And I think that is very significant here. When you have got a co-defendant who pled guilty and said that he was a co-conspirator, he never testified anything about Shannon Drake, and he was her supervisor. He was the one who told her what to do. And the government seems to continue to just ignore that. But that's an important key element here. Every case I tried, the co-defendants come in and they testify about what the other people and all the other co-defendants did. The government charged 2 different conspiracies here, and they involved Doug Courier, and that did not happen. We certainly understand it's a high burden, but the facts in this case warrant this case to be remanded back to the district court for them to really take a look at all of the various evidence here. And I also have to say that the judge did, in its April 18th opinion, when it was talking about what happened with the misstatements and being misled, said at page 67, which would have been, it's page 878 in the joint appendix, the court is very concerned about what occurred in this case, namely with the prosecutor's comments made to Drake, defense counsel, the grand jury, and this court. And the judge had already said earlier that they were misled. So I'd submit that, yes, the judge admitted he was misled. And then we have the footnote there saying that he's going to take further action. He's under advisement. So when you look at all the facts of this case, it warrants consideration of remand back to the district court to look closely at all the various factors. And that the fact that he relied so heavily on the testimony of a grand jury witness that was totally untested should certainly be commented and distinguished. Thank you so much. I appreciate it.
Thank you very much, Counsel. Thank you so much. I appreciate it. And we wish you well. Thank you so much for your arguments here today. We'll ask the clerk to adjourn the court. Sine die.
This honorable court stands adjourned, signed, God save the United States, and this honorable court.